Swayam Prabha. Digital India. Educated India.
Good morning, students. My name is Shalini Sharma. I am working child right professional with an experience of 5.5 years as chairperson Child Welfare Committee and 1.5 year in my present role as member Juvenile Justice Board. Today, I am here to take your course on Juvenile Justice Care and Protection of Children Act 2015, and our module for the day is adoption. We will read some important definitions. We will understand who are the children who are free for adoption, what is the procedure for declaring child legally free for adoption. We will also look at the eligibility of the prospective adoptive parents, and we will also understand adoption procedures. Students, in our previous modules, so far we have studied the growth of Juvenile Justice Act in India before it attained its present form. We also studied about Child Welfare Committees, a statutory body to deal with the children in need of care and protection. We also studied about Juvenile Justice Board, a statutory body to deal with the children in conflict with the law. We also studied about child care institutions, their classifications and mandatory services provided by them. We also studied about 3 kinds of non-institutional services provided in JJ Act, that is sponsorship, foster care and aftercare. And today in this module, we will start with the 4th non-institutional services, that is adoption. Recognizing the importance of adoption, the Juvenile Justice Act has a separate chapter on it. So, students, let's understand the background for adoption. Adoption in India for a long time fell within the ambit of personal laws, and there was no uniform legal framework that governed the adoption of children. The adoption was purely a religious matter, and members of many religions were prohibited from adopting a child as their personal laws did not permit it. Adoption plays a crucial role in India's societal fabric, addressing various social, cultural and humanitarian needs. Adoption provides vulnerable children, including orphaned, abandoned and surrendered children, with a loving and stable family environment. It offers them the opportunity for emotional security, education, health care and overall well-being. Adoption confers to children the right to inheritance, succession and other legal benefits, providing them with the same benefits as biological children. Adoption promotes social inclusion and acceptance by breaking down barriers based on biological lineage or caste. That means, if you are not a biological child of a family, but after adoption you can inherit the property. It fosters a sense of belonging and equality irrespective of the child's background or circumstances of birth. In fact, child's best interest shall be of paramount consideration while processing any adoption placement. That is, now we have moved from the stage of right to parenthood to the best interest of the child, and the best interest of the child shall be the paramount for any adoption. In 2015, when new Juvenile Justice Act was enacted, and amongst other things, it also introduced a uniform legal work for adoption in India. JJ Act 2015 includes a separate chapter on adoption. Adoption is a legal process by nature. The present system of adoption, governed by the Juvenile Justice Care and Protection of Children Act 2015, is the primary legislation for ensuring the safety, security, dignity and well-being of the child, and adoption is also guided by the Juvenile Justice Act. Now students, let's see what the definition of the adoption says. Adoption, according to section 2 subclause 2 of the Juvenile Justice Act, it means the process through which the adopted child is permanently separated from his biological parents and becomes the lawful child of his adoptive parents with all the rights, privileges and responsibilities that are attached to a biological child. So, in simple words, we can say after adoption, a child is permanently separated from his biological family and becomes a legal member of the new adoptive family. Some important definitions, understanding of which will help us to understand this chapter nicely. Let us see. First definition, child legally free for adoption. Section 2, subclause 16 says, it means a child declared legally free for adoption by the Child Welfare Committee after making due inquiry under section 38. So, any child to be given for adoption has to be declared legally free for adoption by the concerned Child Welfare Committee. It is a prerequisite and a mandatory requirement. Second, abandoned. Section 2, subclause 1. It means a child deserted by his biological or adoptive parents or guardians who has been declared abandoned by the Child Welfare Committee after due inquiry. It means that kind of a child who has no one to take care of him, and after the inquiry also no legal guardian of the child were found. Third, home study report. It means a report containing details of the adoptive parents, which include their social and economic status, family background, description of home, standard of living, compatibility between spouses and other family members' health status. So, this is a report of a family of a prospective adoptive parents with whom the child will be placed after the adoption. Surrendered child. Section 2, subclause 60 means a child who in the opinion of the Child Welfare Committee is relinquished on account of physical, emotional and social factors beyond the control of the parent or the legal guardian. This means this is that kind of a child who has been willfully surrendered before the Child Welfare Committee by the parents for the reasons beyond their control. Central Adoption Resource Authority. According to section 68 Juvenile Justice Act, CARA is the central authority of India which is mandated to promote and facilitate domestic adoptions. CARA has authority to regulate inter-country adoptions and also frame adoption regulations from time to time and to function as central authority under the Hague Convention in respect of inter-country adoptions. Now, students, let us understand who are prospective adoptive parents, which is defined in section 2, subclause 49. It means a person or persons eligible to adopt a child as per the provision of section 57. It means prospective adoptive parents or those couples or a person who has shown willingness to adopt a child. Now, let us see what the term relative means. Section 2, subclause 52 says, relative in relation to a child for the purpose of adoption under this Act means a paternal uncle or aunt, a maternal uncle or aunt, a paternal grandparent or maternal grandparent who can adopt the child under relative. Inter-country adoption. Section 2, subclause 34 says, it means adoption of a child from India by a non-resident Indian or by a person of Indian origin or by a foreigner. Hard to place children. These are those children who are not placed in the adoption after the stipulated time, and such persons are older and are in the category of 6 to 18 years. Disruption. Disruption is the premature ending of a placement of a child that has been placed for adoption. That means some disturbance has been created in the process of adoption. Now, Specialized Adoption Agency. What we mean by SA? Section 67. SA is established by the state government for dealing with adoptions and related matters in the state. SA helps to facilitate the process of adoption for the children in its institution along with the other children in the other child care institutions, but those institutions have to be linked with the state adoption agency. What we mean by in-country adoption? It means adoption of a child by a citizen of India, and inter-country adoption, it means an adoption of a child by overseas citizen of India or a foreign national. Now, let us see the category of children who can be adopted. Children eligible for adoption are any orphan or abandoned or surrendered child, but declared legally free for adoption by the Child Welfare Committee. A child of a relative defined under clause 52 of section 2. Child or children of spouses from earlier marriage. Child surrendered by the biological parent for adoption by the step parent. Now, let us see the procedure for declaring child legally free for adoption. As I have explained earlier, any child to be given in adoption has to be declared legally free for adoption by the Child Welfare Committee. So, what are the procedures for declaring a child legally free for adoption? Procedure for declaring a child legally free for adoption in case of an abandoned child is: first, CWC tries to trace the parents and guardians of the child. If the child's status is established as an orphan or abandoned, he or she is declared legally free for adoption. This means that after the inquiry, if CWC is satisfied that no one of the child is found, they can give the child the certificate of legally free for adoption. Now, let us see what is the procedure in case of a surrender child. Parents or guardians are given 2 months' time after surrendering the child to reconsider their decision. After 2 months period, the child is declared legally free for adoption. Process for declaring orphan abandoned children legally free for adoption. First, you have to produce the child before the CWC within 24 hours. This means if anybody, stakeholder, police, DCPU officials happens to encounter an orphan abandoned child, they have to produce that child before the CWC within the 24 hours and submit the report about the circumstances in which the child was found abandoned or alone in the form 17 to the local police station within the 24 hours. Interim care order by the CWC to a SA or a CCI to keep the child pending inquiry. This means that if a child who is found orphan or abandoned is below the 6 years, the child will be placed with the SA and the interim placement order will be issued by the Child Welfare Committee. And if the child is between the age of 6 to 18 years, the child will be case it shall be deemed to be given within 2/4 months. At least 3 members of the CWC shall be giving the order of declaring the child legally free for adoption. That means the order of the Child Welfare Committee in which it declares that such child is legally free for adoption, it has to be signed by the 3 members. Now, a word of caution. If a child is orphaned or abandoned and found by the committee, at the first instance, the committee must try to find the biological parents or guardians of the said child. And if after the completion of the search or inquiry, the committee is satisfied and is of opinion that there is no one to take care of the child or no one is found, they will then only declare the child legally free for adoption. And this declaration should be done within 2 months for children under 2 years of age and within 4 months for older than 2 years of age. Now, let us see what is the process of declaring a surrendered child legally free for adoption. Till now, we have studied the process of declaring abandoned and orphan child legally free for adoption. Now, we will understand the process of declaring surrendered child free for adoption. Parent or guardian wanting to surrender a child shall produce the child before the CWC for surrendering the child. That means, if biological parents wanted to surrender their child or guardians wanted to surrender the child, they have to produce the child before the Child Welfare Committee. And if the committee is satisfied that the parents or the guardians are surrendering the child for the socio-economic or physical conditions beyond their control, and if the committee is also satisfied that this surrender is in the best interest of the child, can register the case. And after counseling of the parents, the child can be surrendered but in camera, and a surrender deed shall be executed by the parent or guardian before the CWC. That means a surrender deed has to be signed, and that too in the presence of the Child Welfare Committee. And after the signing of the deed, a 60 days reconsideration period is available to the parents or guardians surrendering the child from the deed of surrender. No public notice or advertisement shall be issued in case of surrendered child. In case of orphan and abandoned child, publication is important, but in case of surrendered child, the proceedings have to be in camera, so no publication is allowed. CWC shall issue an order declaring the child legally free for adoption after the expiry of 60 days from the date of surrender. So, after the expiry of 60 days, CWC has to declare the child legally free for adoption. Now, let us see the eligibility of the prospective adoptive parents according to section 57 of the Juvenile Justice Act. Any prospective adoptive parent, irrespective of their marital status and whether or not they have biological son or daughter, can adopt a child subject to the following. A. The consent of both the spouses is required for the adoption in case of married couple. That means, if a couple has shown willingness, the consent of both the parents is important. It is not that one has given the consent and other will follow. No, the consent of both the parents is required at the time of the application. A single female is eligible to adopt a child of any gender, whereas a single male cannot adopt a girl child. The prospective adoptive parents have to revalidate their home study report after a period of 3 years. If in 3-year period the prospective adoptive parents have not received any referral, they have to revalidate their home study report again. The seniority of the prospective adoptive parents who have not received a single referral within 3 years shall be counted from the date of registration, except for those who have crossed the composite age of 110 years. The minimum age difference between the child and of the prospective parent is 25 years. No child shall be given in adoption to a couple unless they have at least 2 years of a stable marital relationship. But there is a proviso here. If a relative or step parent, then this clause of a stable 2-year marital relationship has been withdrawn. In case of a couple, the composite age of the prospective adoptive parent shall be considered. The age criteria for prospective adoptive parents shall not be applicable in case of adoption by relative or step parent. Couples with 2 or more children shall only be considered for a specially need child and hard to place child. Now, let us see the composite age and the maximum age of single pap vis-a-vis the age of child. The age of paps on the date of registration shall be counted for deciding their eligibility for children of different age groups. Up to 2 years of child will be given to a couple who have a composite age of 85 years, and of a single parent it shall not be more than 40 years. Above 2 and up to 4 years. If a child is between 2 to 4 years, the maximum composite age of the couple shall be 90 years, and for a single pap it shall not be more than 45 years. And above, if a child is above 4 and to 8 years, the maximum composite age of the couple shall be 100 years, and for a single pap it shall not be more than 50 years. And age of the child above 8 and up to 18 years, maximum composite age of the couple is 110 years. Maximum age of a single pap is 55 years. So, children, here I want to highlight that children up to the age of 18 years can be given in adoption. In addition to these conditions, there are few other basic requirements for the PAPs. All the PAPs should be physically capable, mentally stable, emotionally strong, financially capable. They should not have any threatening medical conditions, and they should be person of clear character. PAPs should not have been convicted in criminal act or accused in any case of child rights violation. Now, children, if we wish to apply, which forum we have to go? For adoption, we have to apply in carings.wcd.gov.in. A toll-free helpline of CARA is, and it's available between 8 a.m. to 8 p.m. on all working days, Monday to Friday. Juvenile Justice Care and Protection Amendment Act 2021 provided strength to the provision of adoption. Many adoption cases earlier used to be pending before the courts for long time, and to make the proceedings of the adoption faster, the power of the court is transferred to the district magistrate. Now, children, we cannot understand adoption without understanding the adoption regulations. And in 2021, to make the process of adoption faster, instead of court, the power has been given to the district magistrates. The Juvenile Justice Care and Protection of Children Amendment Act provided that district magistrate now has the authority to issue adoption orders now. Let's see the legal procedure for adoption. First, the specialized adoption agency shall file the adoption petition in the office of the DM, having jurisdiction over the place where the SA is located. Within 7 days from the date of acceptance of prospective adoptive parents for obtaining the necessary adoption order under the Act. Subclause 2, in case the child is from the children home which is located in another district, the specialized adoption agency shall file the adoption petition before the concerned district magistrate. The district magistrate will hold the adoption proceedings in camera and dispose of the case within period of 2 months or 60 days from the date of the filing of adoption petition by the specialized adoption agency. The specialized adoption agency shall obtain a certified copy of the adoption order from the district magistrate and will forward it to the prospective adoptive parents within the 10 days, and it shall also post a copy of such order in the child adoption resource information and guidance system and make necessary entries in child adoption resource information and guidance system. So, children, here everything is made time bound. Registration of an adoption deed shall not be necessary from now onwards. The specialization adoption agency shall obtain the birth certificate of the child from the birth certificate issuing authority within the 10 days from the date of the adoption order, with the name of adoptive parents as parents and date of birth as recorded in the adoption order. And the SA has been made the agency for compilation of all the paperwork. Earlier, the focus was on parents who have to run around. That is why the adoption rate was very slow in India. To combat this, the DM is made the order issuing authority, and for the paperwork it has been distributed to the specialized adoption agency. Now, let us see the section 61, procedure for disposal of adoption proceedings. Before issuing an adoption order, the district magistrate shall satisfy itself that the adoption is for the welfare of the child. Due consideration is given to the wishes of the child, having regard to the age and understanding of the child. If the child is mature enough to express his wishes, the DM must ensure that the child is willing and ready for the adoption. Third, that neither the prospective adoptive parents has given or agreed to give the specialized adoption agency or the parent or guardian of the child in case of relative adoption has received or agreed to receive any payment or reward in consideration of the adoption. So, this has to check that the adoption is not in lieu of any monetary consideration, except as permitted under the adoption regulations framed by the authority towards the adoption fee or service charge of a child care corpus. So, a adoption fee has to be given by the prospective adoptive parents, but nothing else beyond that, and DM before giving the order has to ensure that no money transaction has been taken place between any of the parties. The adoption proceeding shall be held in camera and the case shall be disposed of by the district magistrate within a period of 2 months from the date of filing. Now, let us see effect of adoption. A child in respect of whom an adoption order is issued by the district magistrate shall become the child of the adoptive parents, and the adoptive parents shall become the parents of the child as if the child had been born to them. After the adoption order, the child becomes the legal child of the adopted parents for all purposes, including intestacy, with effect from the date on which the adoption order takes effect, and on and from such date all the ties of the child in the family of his or her birth shall stand severed and replaced by those created by the adoption order in the adoptive family. So, after the adoption, the ties of the child with the biological family are extinguished and his new ties are established with the family of the adoptive parents. So, there is one proviso to section 63 which says that any property which has vested in the adopted child immediately before the date on which the adoption order takes effect shall continue to vest in the adopted child subject to the obligations, if any, attached to the ownership of such property, including the obligations, if any, to maintain the relatives in the biological family. Now, section 64, reporting of adoption. Notwithstanding anything contained in any other law for the time being in force, information regarding all adoption orders issued by the district magistrate shall be forwarded to the authority, here means CARA, on monthly basis in the manner as provided in the adoption regulations framed by the authority, so as to enable CARA to maintain the data on adoption. Now, let us see the new amendments in adoption regulations 2022. Students, as I have said earlier, we cannot understand adoption without understanding the adoption regulations. The recent amendment have given the power to district magistrate for issuing orders in adoption cases, consequently reducing the burden on court and increasing the accountability of district magistrate and speedy disposal of cases of adoption. So, for the speedy disposal of the cases of adoption, DM has been made the order issuing authority. All the cases pertaining to adoption matters pending before the court shall stand transferred to the district magistrate from the date of notification of these regulations. So, the matters which were pending before the court will now be transferred to the office of the district magistrate. Provision of appeal in adoption orders before the divisional commissioner has also been given with the time limit of disposal of case within 4 weeks. So, if there is an appeal against the order of the adoption by the district magistrate, the aggrieved party can make an appeal to the divisional commissioner within 4 weeks. Prospective adoptive parents with 2 or more children shall not qualify to get referral of a normal child, which was earlier 3 or more children in adoption regulation 2017. As I have said earlier, it is not about the right to parenthood, it is the best interest of the child. So, any family which has their own 2 children cannot apply for the adoption of a 3rd child, although for special need child they can still be considered. Couples with 2 or more children shall only be considered for special needs children as specified in clause 25 of regulation 2 and hard to place children as stated in clause 13 of regulation, unless they are relatives or stepchildren of adoption regulations. Now, this bar has also been taken for relatives or stepchildren adoption if in that case the paps have more than 2 own children, they can still apply for step parent or relative adoption. The maximum composite age of prospective adoptive parents has been reduced to 85 years from 90 years and maximum age of single prospective adoptive parent has been reduced to 40 from 45 years to adopt a child up to 2 years of age. And now, a new chapter of foster care adoption has been added in Adoption Regulation 2022, wherein children who are not being adopted after being declared legally free for adoption may be eligible for foster care who can later be adopted by the foster parents. So, if there are few children who after being declared by the Child Welfare Committee as legally free for adoption, but they are not selected for the adoption, such children can also be given in foster care adoption, and the foster parents may later acquire the right of adoption of such children. Prospective adoptive parents would be barred for 1 year if they do not reserve a child after 3 referrals. Foreign PAPs debarred after 2 referrals, they can re-register. Now, this clause says if PAPs refuses 3 referrals, means if 3 children are shown to them and they did not select any, they are barred for 1 year and they have to re-register again after 1 year. And if foreign PAPs, if the prospective adoptive parents are of a foreign nationality, and if after 2 referrals they did not select a child, they will be barred and they also can re-register. If the adoptive parents are found to be the cause of the disruption or dissolution, they shall be barred from adopting again. As I explained, if there is any disturbance in the process of adoption and that disturbance is because of the prospective adoptive parents, they will be barred from adoption again. Home study report can be done both by the specialized adoption agency and district child protection unit, and the
Time to conduct HSR
has been increased from 1 month to 2 months. Now, the HSR of a prospective adoptive parents can be maintained within 2 months. SA shall file an application with the district magistrate of the district through district child protection unit where the child is located, along with the relevant documents as provided in the schedule 9 within 10 days. If a child has been selected after the referral, the SA will send that application for adoption along with the relevant documents to the district magistrate, but through the DCPU unit. DM shall issue adoption order within a maximum period of 60 days, which was earlier issued by the respective court. The adoption order which was earlier issued by the court has now been made to be issued by the district magistrate, but again it has been made time bound, that is within the 60 days. And if the order is not issued by the DM within the 60 days, the appeal can move to the divisional commissioner. The chief medical officer of the district shall facilitate the treatment of children having special needs housed in the SA or CCI through the existing central government or the state government schemes, and shall declare the health status of the child as normal or having special needs as provided in the
Schedule 18
and Schedule 3rd Part E within a period of 15 days, and also encourage treatment of such children under various schemes of the government. Now, the chief medical officer of the district has been made the officer
in charge
to check the health status of the children staying in the CCIs and also of the infants staying in the SA, and he is the authority who will declare the health status, whether the child is normal or is the child having a child with special needs. Now, let us see the role of Child Welfare Committee in adoption process. Admission of orphan, abandoned and surrendered child. If there is any information about orphan, abandoned and surrendered child, the committee will receive the child,
issuing legally free
for adoption certificate. After thorough inquiry, the committee will declare the LFA or the legally free for adoption certificate to the orphan, abandoned and surrendered or older child. Older child we means those children who have been staying in CCI and nobody ever reported to meet them or claim their guardianship. LFA, certificate to be uploaded by SA within the 48 hours of receiving it. If the LFA certificate has been issued by the Child Welfare Committee, it is the duty of the SA to upload it in the concerned portal within the 48 hours of receiving it. It can direct DCPU to trace biological parents of orphan abandoned child through newspaper and report back to CWC within 30 days. As I explained earlier, the prime duty of the Child Welfare Committee is to trace the original biological parents of the child, and it is their duty to direct DCPU to trace biological parents of orphan abandoned child through newspaper and report back to CWC within 30 days. As I explained earlier, students, the main duty of the Child Welfare Committee is to trace the biological parents of the orphan abandoned child, and for this they can issue an order to the District Child Protection Unit to issue the publication or the photo of the child if they deem it necessary, and the District Child Protection Unit is
duty bound
to do this within the concerned time and submit the compliance report within the 30 days. Certificate of non-traceability of biological parents from the police. Before declaring any child legally free for adoption, the Child Welfare Committee has to take a certificate of a non-traceability, a report from the concerned station that no one of the child has been found after the due inquiry, and the time period for is, if a child is below the 2 years, the police has to issue this certificate within the 2 months, and if the child is above 2 years, the police has to submit this certificate of non-traceability of parents within the 4 months. After ascertaining orphan or abandoned, CWC to declare orphan or abandoned child LFA within 3 days of completion of 2 to 4 months as applicable. If CWC after inquiry is satisfied that the said child who is below 2 years, no trace of his family has been found, they have to give the LFA, the legally free for adoption certificate, within the 3 working days. And if the child is above 4 years and the committee is satisfied within the 4 months that no biological parents of the guardians of the child has been found, they have to issue the legally free for certificate within the 4 months. After ascertaining orphan or abandoned, CWC to declare orphan or abandoned child legally free for adoption certificate within the Schedule 1 in 3 days. If the child is below the 2 years, the committee has to give that LFA certificate within the 2 months, and if the child is above 2 years, the committee has to issue the certificate within the 4 months, but after the report of the inquiry, and within the 10 days of declaration of legally free for adoption certificate, the specialized adoption agency to upload the medical report and the child study report of a child on the concerned portal. Declaring a child of parents with mental illness or intellectual disability as legally free for adoption. Now, in this case, if a child to be given for adoption is born to the parents who are parents with a mental illness or intellectual disability and cannot give their consent, in this case, a certificate declaring parents' disability has to be given by the medical board, by the state or the central government, and after obtaining the certificate, the Child Welfare Committee can declare that child as legally free for adoption. Is also to be borne by the Child Welfare Committee that if there are siblings or twin children, they have to be declared legally free for adoption in one single order. A parent or a guardian wishing to surrender a child shall apply to the Child Welfare Committee. Now, the parents, because of their socio, physical or economic reasons who wanted to surrender their child, they have to surrender the child only before the Child Welfare Committee. The surrender of child or children by the biological parents for the adoption by the step parent shall be before the Child Welfare Committee in the format provided in the Schedule 20. Now, if any biological parent wants to surrender their child, they can do it before the Child Welfare Committee. Non-adjustment of both the child and the adoptive family with each other after adoption. Now, if adoption has been done and the child and the family are not adjusting with each other, then the role of CWC again comes. First, to arrange counseling for such family by the SA or DCPU within the 7 days with due intimation to the State Adoption Resource Agency and the District Magistrate. The news about this disruption has to be shared with the State Adoption Resource Agency and the District Magistrate that a child or the family are not adjusting well. In case of non-compliance for 3 consecutive post-adoption follow-ups, in case if PRAPs are not willing for the post-adoption follow-ups, the District Child Protection Unit shall prepare the social investigation report and inform the Child Welfare Committee for further action as may deem fit. One of the guidelines of the adoption regulation is that even after the adoption, the parents have to willingly get their post-adoption follow-up, and in case if 3 follow-ups are missed by the prospective adoptive parents, the DCPU shall inform in a report to the concerned Child Welfare Committee, and the Child Welfare Committee will take the further necessary action as they deem fit. Disruption. Adoption application, if filed, shall be withdrawn by SA with prior permission of Child Welfare Committee. If the parents wants to disrupt the adoption procedure or want to dissolve the adoption proceedings, they shall
Withdraw it
with the prior permission of Child Welfare Committee. SA to report all cases of admissions, restorations, transfer, death and adoption of children, as well as about children missing from the institution, if any, to the Child Welfare Committee, District Child Protection Unit, State Adoption Resource Agency and the authority through the designated portal. So, it is the duty designated to SA that they should report to the Child Welfare Committee about all the children staying in the SA regarding their restoration, regarding their transfer, regarding the death
of any child who was placed in the SA.
and adoption of all children. This information has to be shared by the in charge SA with the Child Welfare Committee. For the relative adoption, consent of biological parents or permission of the Child Welfare Committee. For the relative adoption, consent of biological parents or permission has to be given before the Child Welfare Committee. In the case of inter-country adoption by step parent, the process has to be followed as outlined in inter-country relative adoption. Now, let us look at some cases where judiciary has explained the concept of adoption. First case, in Rene's adoption. This case is of year 2000. Sushmita Sen, former Miss Universe, adopted her first daughter, Rene, in 2000 when she herself was 25 years old. She was single at that time, which was relatively uncommon in India for someone to adopt as a single parent. Rene's adoption marked a significant movement in Indian society as Sushmita Sen challenged societal norms by becoming a single mother through adoption. From 2000 to 2010, Sushmita Sen again expanded her family by adopting her second daughter. Sushmita Sen reiterated her commitment to motherhood and adoption, further inspiring others to consider adoption as a means of building family. Sushmita Sen's courage in breaking societal norms and emphasizing the importance of providing loving and nurturing homes to children in need of care and protection through her actions and advocacy. Miss Sen has played a significant role in challenging stereotypes and promoting adoption as a viable option for building a family. In another judgment, Lakshmi Kant Pandey versus Union of India. In this landmark case, the Supreme Court of India recognized the principle of best interest of the child as a paramount in adoption cases. This case arose from a challenge to the validity of the Hindu Adoption and Maintenance Act 1956, which only allowed adoption of a son but not of a daughter. The Supreme Court held that gender discrimination in adoption was unconstitutional and emphasized that the welfare of the child should be the primary consideration in adoption cases and not the gender. The judgment played a crucial role in promoting gender neutral adoption laws in India and established the principle that the best interest of the child should guide all decisions relating to adoption. In a third landmark case, Shabnam Hashmi versus Union of India. In this case, the Supreme Court addressed the issue of inter-country adoption and laid down guidelines to regulate such adoptions. The case highlighted the concerns about the exploitation and trafficking of children under the garb of inter-country adoption. The Supreme Court emphasized the need for strict regulations to safeguard the rights and welfare of adopted children, including thorough background checks of adoptive parents and monitoring of the adoption process. The judgment led to the formation of the Guidelines Governing Adoption of Children 2015, which provide comprehensive regulations for inter-country adoption in India, ensuring greater transparency and accountability in the process. So, to conclude, students, the legal process for adoption in India involves various steps to ensure the welfare of the child. Prospective adoptive parents have to go through a formal application process, which includes background and checks, home visits and interviews to assess their suitability as an adoptive parents. Indian law, specifically the Juvenile Justice Care and Protection of Children Act 2015, governs the adoption process. This act outlines the procedures and regulations for adoption in India, aiming to protect the right and well-being of children. The new amendment and the new regulations have authorized the DMs and the additional DMs to issue adoption order. Children, today we have tried to understand the concept of adoption, which is a very noble cause. And for the children who are staying in institutions and for those children who don't have anyone to call as their own, the adoption regulations and the adoption is a noble mean of building families. So, as students, as responsible citizens of India, we should promote more and more adoption and to give every child right to family. With this, I conclude today's lecture. Thank you.
Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. Today I am going to tell you about an important debate that is occurring around the concept of globalization. Now, uh, within the study of globalization, there are two sets of people. The first set of people argue that globalization is very real. It's something that is happening around us all the time, and in fact, it's something that is gaining strength over time. The second set of people, and the first set of people are called the globalists. The second set of people are not so convinced that globalization is something real, and they are referred to as skeptics. Now, the skeptics argue that unlike what the globalists would have us believe, that there are things and ideas and people that are traveling across the world, across multiple borders, and that we live in an interconnected world, actually there are many parts of the world and many types of people who are completely left out of these kind of global flows. So they would give you the example of typically indigenous communities who live across the world. And they would argue that if you look at the lives of indigenous communities, particularly tribes that are quite isolated in terms of their physical location, their lives continue without their participating in any kind of global flows. To this, the globalists would respond that even though people may live in isolated and remote locations and they may not be directly involved in global flows, their lives today are still being influenced by events that are happening at a global scale. You can take the example of climate change. So, for instance, if there is an indigenous community that has no contact with anyone else in the world apart from themselves, but they live in an area which is experiencing an increase in sea levels and increase in the temperature. All of this may be attributed to people in neighboring countries, or actually rather events that are happening across the globe. So in that sense, even though you may not be directly participating in global flows, your everyday life is affected by what is happening around the world. Another argument that the skeptics make is in regard to what happens with the nation states. Now, initially, when discussions about globalization started, and we are talking about the 1990s, the expectation was that the nation state as an entity is going to wither away. It's going to cease to be important. Now, skeptics could point out to the world today and say, well, nation states are still important. We still live our lives based on which nation we were born in or which nation we have citizenship in. Their rules and regulations are still important for us. To which globalists would argue that this expectation that the nation state will cease to be important, that itself is a fallacy. Rather than facing a situation that the nation state becomes less important over time, we actually may be headed towards a situation where, in addition to the nation state, there are other laws which become important to our lives and they shape our lives on an everyday basis.